forms. So elder law in general encompasses two phases. Elder law planning, which is, to be honest, pre-death, and then probate and administration, which is after somebody passes away. And both of them are, I think, very interesting practices. I happen to do a lot more in the probate and administration portion, but I would say at least 40% of my practice is elder planning. I know you probably have heard a lot about elder planning. I wish I could talk about all of it, but that would take about 10 hours. So I'm going to try to focus on the things that you, even as a general practitioner, would probably be called upon to do. So the first thing we're going to discuss is a last will and testament. Why would you have one? What happens if you don't have one? Is it the end of the world? Well, that depends. It depends on what you want to happen to your property. The best part of having a will is that you can decide where your property goes. If you don't have a will, it would depend on your family situation. If you're a person who is married and has children, and you wanted your property to go to your spouse, let's say 100% to your spouse, but you died without a will, you're out of luck. That the law in New York for people who die without a will is called intestacy. It's EBTL 411, and the work thereafter, I think it's 411, 412, etc. 411 says that if you die with a spouse and children, the first $50,000 and the half of the net estate go to your spouse. The other half goes to your children. Now you can see how that would not work out for a lot of people, especially people with minor children. Then there would be a trust established. There would have to be a guardian, which would most likely, of course, be the other spouse. It's very complicated. It's very sticky. If this person had a will, they died with the will, leaving everything to their spouse, no problem. And, of course, in New York and hopefully in federal law again, when we get the estate tax up and running, you can leave as much money as you want to your spouse. They're completely exempt under the marital exemption. That's the only, well, except for charities, that's the only all-encompassing exemption that you find. You have no legal obligation to leave anything to your children. You can leave them zero. I wouldn't do that, but no, you can. I mean, you can leave, if you have 4 children and you want to leave some to 2 and nothing to the other 2, again, no legal obligation. Well, what happens if you have 2 kids and you go to your elder law planner, you get a great will, and the elder law planner puts the kids' names in the will. So I leave everything to my spouse, so-and-so. If my spouse dies before me, I leave everything to my kids, A and B. Well, 10 years down the road, C is born. What happens to C? Well, if you've provided for A and B in the will, C is provided for too. If you haven't provided for A and B, many times C gets nothing too. But again, that would depend. If you've left them something like a Totten trust outside of the estate, sometimes that counts as, I don't want to call their share, but part of their inheritance. All right, so what I guess I'll start first of all is to tell you how to make a valid will in New York. The requirements are very different for different states, and you should be very, very sure of what you're doing. If you're going to do this, New York and New Jersey, for instance, has different standards on what makes a valid will. And what will fly in New York does not fly in New Jersey. Okay, well, what happens if somebody from New Jersey, who lived in New Jersey, had a valid will in New Jersey, moved up to New York in their last couple of years of their life to live with their daughter or their son or whatever? They die in New York. Does that will stand? Yes. Because it was validly executed in New Jersey when that person lived in New Jersey, New York will take it. And that, power of attorneys, etc., that kind of goes across the board. If when they're living in a certain state, that document was properly executed by the laws of those state, by the laws of that state, then New York will take it as a valid document. But in New York, your will has to be in writing. It has to be properly signed by the testator. Does that mean he can't put an X? No. Yeah, you can put an X. Any marking is acceptable. Do I advise them to sign? Yeah. If you can sign your name, sign your whole name. Can a power of attorney, a person, agent, sign for the will? Yes. If they have a proper power within the power of attorney form that says that they can execute or do estate planning documents, etc., then they can sign a will or a trust or whatever for the principal, the person who you would want to have the will for. The testator has to declare this to be their last will and testament. Believe it or not, I sit there every single execution, I love that word, but that's what we call it, and read this paragraph to them. You know, on this day, this person came before me in front of these two witnesses, A and B, and did this and that and the other thing, and then signs it at the end. Do you declare this to be your last will and testament? I do. Do you want Joe and Joan to be your witnesses? I do. Do you understand what this is? I do. Do you understand your property and who you're giving it to? I do. If there's any question about that testator, any at all about their competency, maybe they've had a stroke and they don't speak clearly, whatever, go to the maximum extent you can to make sure that not only you, but those two witnesses understand that that person is signing what they want to sign. Because when a contest comes about, and it might, you have the affidavits of the witnesses. You may do an additional affidavit if you feel the case is kind of shaky, and we'll talk about one of my favorites later.